you already know, we're going to talk about patents and trademarks for startups. So, let's get right into it. So this is basically a quick overview of today's presentation. We're going to do a quick overview. I'm going to talk a little bit about trademarks, and after we talk about trademarks, the bulk of the presentation, we're going to talk about patents. So, what is a patent? How you file a patent? How you actually do the filing? And then what happens at the patent office? There's actually a question about domain names, so if there's time at the end, I'm happy to take questions and talk about domain names. And I'm fine with taking questions during the presentation. Just try and keep them like on the slide, and then at the end, I'll take any general questions, any questions on other issues, or come speak to me afterwards. So this is me, this is what I do. I'm patentablenj.com, because I'm in New Jersey. When I'm in New York, I say I'm patentablenny.com. I do work I do work anywhere. My furthest client so far is Hong Kong. I think Afghanistan isn't quite as far. He's in the Army, so there's a client in Pakistan too. But anyway, patents are the United States. I do U.S. patents. I also do filings around the world. I handle all aspects of patents, trademarks, copyrights, domain disputes. Previous lifetime, I used to do web pages. I run Linux, so I had trouble getting things started this morning because you can do more, but invariably more stuff can go wrong. And some of my work, just to give you some background of what I do, I'm actually going to talk about this one a bit today. Use phones bid at an auction. That's patent number 7783526. I got that patent. These are ones that I thought would be most relevant to NJ Tech meetup. Change the amplitude as you bend the endoscope. I got that patent too. That's patent 7942809. And one of my more recent ones is patent 8048231. We've now crossed it to 8 million patents. This one issued a couple months ago for cavitation sonic wave cleaners. This is the type of thing I do. You have a new concept, whether it be like an iPhone app or medical devices, that one was, or consumer device. Those are all different types of things that you can patent. So, still we're in the intro section. These are the different types of intellectual property. We've got patents, trademarks, copyrights, trade secrets. So a patent is any new and useful process, machine, manufacture, composition of matter, any new useful improvement thereof. 35 U.S.C. 101, basis of patent law. So patent is basically what we consider an invention. Today, sometimes we don't consider these things inventions so much, but we might say new technology. Whatever the new technology is, whether it be a new method of auctioning using your cell phone data plan, or it's a new type of light bulb, to use the classic example, or whatever it is. Trademarks, it identifies products or services consumers with which the trademark appears to originate from a unique source. I pulled that one from Wikipedia. It's not quite as authoritative, but I thought it was a good definition. In other words, it's anything that identifies a source. If you have M&M's written on your candy, that identifies the source. I know it's coming from a certain company in wherever they are in Pennsylvania, I believe, and I know I'm going to get the same candy from them. Someone else can't go and call the products M&M because I don't know if it's the same quality. I don't know if the advertising dollars that are putting into it are going to that name. Just briefly, domains can come under trademarks. It depends what you sell. So if you have a domain for M&M, well, their trademark is probably so broad that they're going to be able to get that domain from you in a dispute. But on the other hand, if you have, say, Mission 50, and there's a mission50.com, which is registered to another organization somewhere, they're allowed to do that. Now, it depends what happens. If you've trademarked Mission 50, they're not going to be able to use on their website things related to it. You have a trademark for Mission 50 that covers goods such as entrepreneurial services, startup services, business incubator, that type of thing. They're not going to be able to use mission50.com for that because that is confusingly similar. But if they're using Mission 50 as, say, I don't know, first thing that comes to mind, be a missionary, then that's not confusingly similar. So, because they're using for different types of goods. So, in a domain dispute, it has to be infringing upon a trademark first and foremost. They have to have no valid business reason to do it, and they have to be doing it in bad faith. Basically, the only time to take a domain from someone is if they're purposely ripping you off. WIPA, World Intellectual Property Organization, I mean, my opinion is they didn't want to deal with it. They didn't want to be lawyers. The whole purpose of domain disputes, and it's the only time I'm going to talk about it unless you ask me questions at the end. The whole purpose of domain name disputes is just they wanted to clear out names that shouldn't have been registered. Like when everyone was registering .coms, if you register abcnews.com, you're not ABC News, they wanted a quick and simple way to go give it to ABC and not have to take every one of those cases to court. But for the most part, domain name disputes are not the easiest thing in the world to do. It has to be all those three things I mentioned. It has to be trademark infringement, they have to have no legitimate business purpose, and they have to have been registered. All right, copyrights, works of authorship, use of tangible means of expression. So copyrights, again, I'm going back quickly here, it's not really the focus of today's presentation, but it is important to know the difference. Copyrights refer to things which are artistic. The guy who designed this, you actually get a design patent on this, but the copyright as an artistic work, you could copyright this light over here, or any of these lights over here that you see. It's interesting where and trade secrets protected with legal rights can reverse engineer. So trade secrets is basically you don't file it because you keep it to yourself and you don't let anyone know. But someone can go and reverse engineer and copy it. Now that's allowed. This is most famously, this is done, Compaq copied the IBM computer. They had two teams. They had one team that was reverse engineering the BIOS, the basic input and output system on the IBM personal computer, and they had another team programming it. So they couldn't be accused of breaking copyrights because they said, well, this team reverse engineered that was allowed. This team just looked at what they gave them, what team one gave to team two when they did it. So where this overlaps, actually a very interesting case. I was actually just interviewed for the New York Times blog on this. Is anyone familiar with, Bikram Yoga? So Bikram Yoga is involved in the lawsuit now, as they tend to be, because they protect their copyright vigorously. They have actually, for those that don't know, because I didn't know until they told me they wanted to interview me and I looked it up, Bikram Yoga is a series of, I believe it's 26 moves, did I get that right? It's not my area of expertise now, I'm getting out of my area here. I think it's 26 successive moves of positions that you do in like 100-degree heat, 90% humidity, and this, he says, has all sorts of medical implications and properties and helps you, and it's hot. This guy is, you know, he's licensing these things all over the world. To become a licensed instructor costs $10,000, and then even then you need his approval to open a Bikram Yoga place. So how does he do this? He's doing this through copyrights. He's actually protected his series of moves. Now there's another one, Yoga for the People. Yoga for the People, not a trademark problem, because yoga is descriptive. I can't, if I call it yoga, I can't protect that name. It's yoga, that's what it is, that's a word out there for anyone to use. So what he's done, he's called it Yoga for the People, which is clearly different than Bikram Yoga in name, but in practice he's doing all of the same steps. And now Yoga for the People is arguing it's a functional thing. That should be patent protection. He has no patent protection, it would be expired by now anyway. Patents expire, copyrights expire, but copyrights expire 70 years after the death of a person if they're filed today. Trademarks can be renewed forever. So he's argued it's functional, it should be patentable. I think Bikram Yoga is going to win in this case because if you have a dance, you know, if you choreograph a dance and you've got 36 moves, or however many it is, that's for sure copyrightable. It's true, there's functional aspects to it, but the same way in a dance there's functional aspects, there's exercise aspects to any dance, but the particular character of the whole thing together, 36 moves, is an artistic work. So that's the type of thing that goes to copyright. These are the kinds of things you can do, even if you're in a field such as you're opening a dance studio, hey, you might have copyrights there, versus if you're opening something that's medical, you might have patents there, or there might be overlap for both.
Excuse me.
Yes?
Could you draw a distinction more between why you go for a patent versus a copyright?
Yes, a patent is functional, a copyright is artistic. What I like about the Bikram Yoga example is I think it crosses over both. It crosses over both. There's functional aspects and there's artistic aspects. He's protected the artistic, not the functional. And in a way, he's created what would otherwise be maybe a patentable system. He's created it and turned it into a copyright, and he's getting rights for much, much longer. You know, I think it's very smart what he did.
So Michael,
Yes.
very, very quickly, if you've got a particular process that you can apply in a bank, for example, would that be for accounting? Would that be could that be a copyright, so to say? I mean, the code itself.
Yes, but in that case, it's probably not particularly useful. You can copyright code, but you can reverse engineer. Someone else can look at this and they can code it themselves, as long as they're not copying your code.
So how would you protect it? I mean, how would you, for example, Apple?
It might not
protect its look and feel of the.
Oh, okay, look and
iPhone,
feel.
for example.
Well, the look and feel, you could copyright that as the look of it, and also it goes to design patent. Apple files design patents left and right. So, for example, the look and feel of, I'm using this voice recorder here. This is a Samsung Zoom. Yeah, they probably copyrighted the look of that. I can't copyright, I'm sorry, design patent, the look of that. We'll get to design patents. And the same thing, this mouse here, my hand was trying to kill me because I use a computer all day, so I had a sideways mouse. I didn't look it up, but I'm sure if they didn't, they were silly not to, but I'm sure this was, they filed a design patent and look at this mouse that you hold sideways. I mean, even Microsoft, Logitech, on the regular mouses, they design patent everything. So I can't copy the look of the object. All right, any more just general questions on this before we move on to patents? Okay, let's move on. So, I'm sorry, before we move on to trademarks. So I'm going to talk about trademarks now before we get into nitty-gritty. So a trademark. So again, just a quick overview. Trademark is to protect a source indicator. So it can be a word, a name, a slogan, a symbol, a sound, a smell, a color, anything that's used to indicate a unique source of goods. So my example, this is a real client, Glamour Ride. It's a birthday trailer for girls. He franchises these things out, different location, you get a different guy that you're calling, and you order Glamour Ride, and he comes with this trailer. He's got another one for video games, video game trailer for boys, Glamour Ride for girls, and he'll come with this trailer, and he'll have this whole birthday party in the trailer, and they'll do dress up and makeup and everything else. And that's the name of it. You want to copy his business model? Well, I don't want to speak of whether you can or can't because he's my client, but for sure you can't call it Glamour Ride. Or anything which is confusingly similar. So a specific shade of green for a laundry board, this is hard to protect, this doesn't happen every day, but I have dealt with this. I dealt with this with one restaurant suing another saying that it was too close because they used the same shade as turquoise. So, you know, whatever, we settled that case, but you know, it happens. People claim it's trade dress. People are even confused because it looks too similar. This is only for non-functional things. A trademark is only for non-functional aspects, things which are design aspects. And you go crazy in all these different things. Like another one I'm dealing with recently is handbags. The pattern on the handbags, whether you can protect that as a trademark or a copyright or both. And you actually can. You can protect the pattern on a handbag if you've been using it for 5 years or if you have enough sales. You know, all sorts of things that are protectable. So these are reasons to go to an attorney that knows what he's talking about, hopefully. You go to an attorney, show him what you've got, and let him tell you all the different things that are protectable. At least so you know. You know, you might decide, hey, I don't want to spend the money on protecting the look of my storefront or whatever it is, but these are things which are potentially protectable. And after the fact, when someone copies you, it's usually too late. And then a slogan. If you're buying insurance from another company, then we're both losing money. Well, the first trademarks I ever filed when I went out and started my own firm in 2007. And a service mark is the same as a trademark, except it identifies a service. So it could be something for medical services, legal services, entrepreneurial services, whatever it is. So there must be, I touched upon this before, there can't be a likelihood of confusion. It can't be confusingly similar. If someone has the name Mission 50 for entrepreneurial services, you can't call yourself Mission 50.2 for entrepreneurial services, assuming it's trademarked. There is rights even if you don't file a trademark, but I'm not going to get into that today. It's much lesser rights, much harder. It cannot be merely descriptive of the goods. So I can't call a mouse pad a mouse pad. I can't trademark mouse pad. That actually be generic. It's even worse. Can't describe what it is. I'd have to call this Tom, whatever. It is some name that's different. So primary register is for the things which already have secondary meanings. So like greater than 1 for child handles, Greater than 1, I don't know immediately it's a child handle. It has, I'm giving it a different meaning. Greater than 1 in the English language means 2, 3, 4, 5, 6, 7. Greater than 1 in this case is a secondary meaning. Its meaning is, I'm referring to a child handle. The child holds on to this thing, the parent holds on to the other, everything you want. That's what this thing is. Supplemental register is things that don't have secondary meaning right now. So, for example, I gave the example already of the purse. The design of the purse wouldn't necessarily associate it with it, but the law associated with having a different meaning, associating that with purses. But after 5 years of sales or significant use in commerce, the law is that it is considered to have secondary meaning. Remote landlord is another one. Kind of describes what it is. It's, I'm being a landlord from afar, but after 5 years of use, hey, now that's considered to have secondary meaning. Now it refers to this product that he's selling for this online web portal to manage your landlord things and look at your cameras and so forth. Any questions? Yes?
If you've got a copyright or patent, trademark is separate, you still have to apply separately.
Yes, very different. So the Patent and Trademark Office, actually it's one physical office. Actually now a lot of them, the trademark examiners are telecommuting these days, but they're separate departments within the same office, the same David Kapos, head of both of them. Copyright Office is totally separate. What I call the Copyright Office, it's like calling the librarian. What I call the Patent Office, it's like calling the government office. They're very different. Yes?
If you want to skip this, you can, but how did Donald Trump trademark "you're fired"? Because that's
secondary meaning. So I don't know. I have to look at the goods and services. You know, save it at the end. I'll look up the trademark at the Trademark Office. I don't want to interrupt the presentation, but at the end I'll be happy to look it up. So just remember that question, and we'll look up his trademark, and I'll see what are the goods. Because if he said for firing a person, it's probably not getting through. But if he said for I don't know what, for a TV slogan or something, I don't know. I'd have to think about it. But let's look it up. I never heard that, but let's look if there is a trademark and how it was filed. Okay. So trademark clearance searches. So this, I touched upon this. People can be using names, but they haven't necessarily registered them. So we can do a preliminary search, which is more or less what the Trademark Office will do. And let's put it this way, it's cheaper. That's why people choose to do this. So in preliminary searches, I'll just look at issued trademarks. I'm going to look at other trademarks out there, which is more or less a straightforward process, although sometimes you have 500 results if you're trying to trademark something with a very common name. And then I'm going to go through them and make sure that it's not confusingly similar. Make sure the goods are different enough that you can get this name. So that's, I wrote it here as knockoff search or preliminary search. But the problem is, marks can still be canceled even after registration. So, supposing, for example, give you a good example of this, Mission 50, since that's where we are. Someone registers the Mission 50 trademark. They get the trademark because the Trademark Office searches. They might do a quick Google search. They might do dictionaries, and they might do. They'll do the trademark database, but they don't come across Mission 50 in Hoboken, New Jersey. So they get the registration. Now, eventually, Aaron back there, he realizes they've trademarked our name. How can they do that? I have particular brand equity in this. I put so much into this. I have 1,200 members. That's crazy they got this trademark. So he comes to me and says, hey, can you do this for free? And I say, yeah, sure. Aaron looks up and I say, I can do it for free. Anyway. And we file to cancel their mark. And it's hopefully a straightforward cancellation, depending on how long it's gone, and depending on how close they are in goods and so forth. You got to make all these fun legal arguments. And we can cancel their mark. Now, really, you want to oppose it. There's an opposition period before registration, which brings me to a different point, that if you do have a trademark, there's watching services, which are a couple $100 a year, to make sure no one else is filing similar marks, so you can oppose them before they even get to registration. But even once they do, you can file for cancellation within reasonable time. I'm not getting into the details. And then, so what I recommend, but to be frank, a lot of people don't do it because it's more expensive, is a full clearance search. This will search periodicals, sound tick searches, all sorts of databases, business records. We'll find out, is there any company in this country that's showing up on this database? And it'll usually, if you find companies, it'll tell you approximately what the sales are and how big they are. you know, it at least gives you some idea. And you can say, hey, do I want to go forward with this, or is there really going to be a problem? Because there's a Mission 50 out there in Albuquerque, New Mexico, and they've got 50,000 members. Probably not, but you know, in that case, you find that and change your name. You know, they just haven't filed a trademark. So registration is good. You want to register. It gives you more rights. It allows you to sue for more damages, puts people on notice, and it takes out this sort of iffy of, well, what if this company went out there, what's that one? Because once you have it, other people who start up, they should hopefully be doing trademark searches and seeing that your name is protected for your goods. Okay, and then this is from my website, which is, again, patentablenj.com, but you can see that graphic better there. But this is basically how long it takes. There are such things as state registrations. I don't bother with them. I never filed one. It's kind of like you pay the state some money and they will put it in their database. It's really not much different than the who's who books where you pay money to these who books and they put you in their book that nobody ever sees. Federal Register is what really matters. It covers the whole country. 4 months till the initial exam. Unless you have a rejection, we have to go back and forth. We might have to provide arguments, which is why we do the searches, so we hopefully avoid the rejection. It'll be about 9 months to a year till allowance. And then it goes to publication, and the public can oppose it before it goes to issuance or negotiate or consent agreements, whatever it could be. And in order to keep it alive, further disclosures at years 5, 9, every 10 years thereafter, we have to renew the trademark. You can renew it forever as long as you're using the trademark. Trademarks are different than copyrights and patents in that sense. As long as you're selling it, you can keep maintaining the trademark. The oldest one I ever renewed dated back to, I think, the 1920s. Doesn't happen every day, but I actually filed a renewal for Beau Brummel for a clothing store. That to renew that trademark.
If you don't renew it, what happens if you don't renew it?
It will go abandoned. If you don't renew it, if you don't pay the renewal fees, it will go abandoned. And the whole reason for that, I mean,
can I go out there and renew that? Can I?
Well, then you would have to refile. So that if the renewal, if it's not renewed, then it will be abandoned, and then you can refile. However, if it's not been renewed because the person was just negligent, then he still has rights to the name because he's still using it. It's called common law rights because there are rights that come from trademarks in England before they had a registration system. So we've maintained that system. So you can still sue a person for trademark infringement, but the damages in the statute aren't nearly as high as if you have a registration. So he's giving up a lot by not maintaining it properly, but it doesn't mean someone else can do it unless they stopped using it. So for example, on point to what you're saying, one of my clients is ProCare Pharmacy. He got the name as CVS, abandoned it, and they actually filed, we're abandoning use. We're no longer using it, they canceled the marks, they were done with it, they didn't want to pay to continue keeping it up, they stopped using the name CVS ProCare. They became just CVS, my client got ProCare Pharmacy, and guess whose calls he gets? He gets business now. So, you know, because people call up and they have CVS and the old 411 systems that haven't been changed properly. Oh, he says CVS, so you want CVS Pro? Do you mean CVS ProCare? Yes, CVS ProCare. We found ProCare Pharmacy, how's that? Sure. You know, that type of thing happens. Any other questions on the timeline? Yes?
What are some things that could not go well?
Likelihood of confusion is the most common rejection. It's confusing, or the most problematic rejection, I should say. I mean, I get other things. The description of the mark isn't proper, like things like this that are easily changeable, but the big one is likelihood of confusion. If I register the name, so this guy's got ProCare Pharmacy, and I register ProCom Pharmacy, then it would be rejected because it's likelihood of confusion. It's too similar. If it's too similar, it's going to confuse people that they're going to think this company is that company. Can't register it. And once you get through that, you might still get opposed by other users. But it's not so common that others oppose. It's more common that you have problems getting it through. All right, any questions from this side of the room? Yes?
I had a mark rejected a few years ago because it was too generic.
That happens as well.
Are there ways around that?
Yeah. Was it generic or descriptive?
Good question. They might have actually said both.
We'll look it up afterwards.
Yeah.
Keep that in mind, we'll look it up. If it's generic, you can't. I can't register tissues for tissues. If it's descriptive, blowing my nose item, and I'm doing tissues, obviously would register that name. Maybe you would, I don't know. People sell all sorts of stuff, crazy names. Blowing my nose item. That would probably be descriptive, it would be rejected, but that would get on the supplemental register. And then in 5 years of use, you can get it on the primary. You still get to use that R with the circle on the supplemental. But keep that in mind for the end, and we'll look up trademarks at the end. Okay, that concludes my talk on trademarks. Now we're going to patents. So, first, what is a patent? This is from the Constitution, Article 1, Section 1, Clause 8. See, I have it memorized. I wasn't looking when I said that. Congress shall have the power to promote the progress of science and useful arts by securing for limited times to inventors exclusive rights to their somethings and discoveries. Interesting choice of periods there. Whoops. Anyway, so for limited times, I can protect an invention. Before, this was 1790, the first statute was enacted for federal patents. Before that, the states had some patent system. But you can imagine, you file your patent in New Jersey and Pennsylvania, someone's infringing, and you would have had to file it in all 13 colonies. It's not fun. The mail apparently went as fast as it did today, but still, you know, it's an expense. You don't know where it's to be sold. You don't know where it's going to infringe. This is one of the things, one of the first things to go federal. I mean, basically, I happen to be a big history fan and constitutional law and all that stuff too, but anything commerce in the Constitution went federal. That was everything. Every state agreed we need a federal commerce system, so we're not fighting each other to the bottom. And this is issued patents year to year. So 1790, there weren't so many. It didn't really start catching on until about the time of Abraham Lincoln, who is the first president, I think only president to ever file a patent application. and World War II, you can see the dip there, changed in the law in the 1950s. But in general, this was a change in law. This was, I think, the State Street decision, which limited business method patents, which we've been fighting about ever since. And you can see this is how many patents are filed a year. And this is the percentage of foreign companies which are filing in the U.S. to get protection here. I do Google Ads around the world, and I file patents for people around the world in the United States, and vice versa. I file them in other countries. But the United States is the most active patent office by far. Second is probably European Patent Office. I think third is South Korea. Korea is crazy with patents. Japan is very big on them too. But our country, by far, I mean, just commerce-wise, the amount of money that goes through this country compared to others eclipses everybody else, and so it should logically follow patents do too. Okay, this is an example of a patent. This is one of them that I referred to in my intro. U.S. patent 7,783,526, issued August 24th, 2010. The title was an unregistered auction device and method for, I forget, but whatever it was. And I've written the claim into English to show you the type of thing that you can claim in a patent. So, a phone with a data plan. Now, I actually wrote it, I didn't call it phone because it's kind of phone, I didn't want to patent phone per se. So I called it a bidirectional transceiver. Can someone translate bidirectional transceiver for me? Aaron, why did I write bidirectional transceiver?
Maybe if other devices came up that weren't called a phone, that could be covered, that, you know,
Yeah.
two-way communication.
Yeah, I mean anything that two-way communication, exactly. A transceiver is anything sending and receiving a signal. Bidirectional is it sends and receives. It's broad, you know? And phone, you know, what do I call a phone? Is this, I don't even know anymore what a phone is. I mean, I can show you my phone. I know my phone's a phone. This is my phone. I just patent this stuff. I use a phone that, like, calls people. So, I don't know if, like, an iPhone is a phone, or just call the phone there, too. Whatever these things are, anything that happens to have phone functionality. So I want anything that has two-way capabilities with data plan. Data plan I didn't write either, so I don't think I did. And it's got a phone plan. And I wrote billing needs. Any way I can bill a person, whether I call it a phone plan or I'm billing a person. And the next step of the claim was I bid on an auction with the phone. So now I take my bidirectional transceiver, is actually what I wrote in the claim, and I bid on an auction. And at least some of the bidders are unknown to the auctioneer. That's what the examiner decided was patentable about it. There's nothing new about a phone that has a phone plan. And you could even argue bidding on an auction with a phone, great, I could take my iPhone or my Android phone, and I could bid on eBay. I mean, there's more to this claim, but for purposes of this example, some of the bidders are unknown to the auctioneer. So what was the aha about this? What was the, oh wow, look at that feature of this that we're able to patent? I don't know who you are. What this client actually wanted to do, and he's looking to license it because he didn't actually do it if anyone wants to license it, he was going to write a billboard in Times Square. You take your phone, you text a certain number, bills your phone plan, or however it worked, it bills your phone plan for the bid, and that's it. It takes it off your phone plan. Now you've bid on this item, you've bid on this diamond necklace up on Times Square, you bid $1,000, and you charged whatever it is, $1 each time you bid. And the winning person ends up getting this thing on there, and we never knew who these people were who were bidding, except for based on their phone plan. We look them up, and then that's how we make sure that they pay. So this is patentable. So if you're coming up with stuff, if you're starting tech business, that's what we do. We try and find ways to take your concept, even if you don't think it's protectable. We try and find ways to protect it, because now, even though he didn't go forward with this, he's a business, he does all sorts of other stuff. He's got a valid patent. It's worth money. You can license it. I mean, looking for a buyer right now, but it's still worth money even on its own. And if you are a company, your company doing it, and you've got a stack of patents like this, you go to sell your company, or you go to get investor funding, worth a hell of a lot more because you got the stack of patents. Alright, so this is the statute as the basic statute of the things that are patentable, which is pretty much as Thomas Jefferson wrote it. He used to say useful arts, now it's different, but it now says useful process. So process is where business method patents come under. John White, the head of the Patent Law Institute, he teaches a lot of classes in patent law, thinks it's a big mistake that they ever changed the process. He thinks they should have said useful arts, and it should have included business methods and all that crazy backlog that we have now, and all the patents that people say, oh, these things shouldn't be patentable. I don't agree with this. Useful process, machine, manufacture, composition of matter, any improvement thereof. So basically, as the Supreme Court said in the 1950s, anything new under the sun made by man, which is a bastardization of a much older quote, which meant the exact opposite, that there's nothing new under the sun, but all right, we'll leave it at that. All right, so what is a patent? So 35 USC 112 tells us what patent is. An inventor has to disclose all of these things to the public. How to make it, how to use it, how to sell it. So he has to disclose basically everything about it. He has to tell the person, in this document, which you read, you will be able to do everything that I am doing here. And in exchange for telling the public how to do all that, we are going to give him 20 years or so. I'm not getting into term extension, all that stuff, but to exclude others from making, selling, using, or importing. Doesn't mean he has the right to do anything, because he could be infringing on other people's patents. But he is going to exclude others. If you go and make, sell, use, or import it, he can sue you for infringement. I should say, anyone can sue anyone for anything in this country, but he can actually win on a suit for infringement. So the idea is that we're going to advance civilization. We're going to get these things out there. If you have this idea, people inherently are self-interested. We want your self-interest to benefit the public. And this benefits everyone in the long run because we get these new ideas out there. Because I can go come up with this idea and I get time to incubate it and sell it without being knocked off by a big guy. And that's, in a nutshell, the purpose of the patent system. All right, let me pause here for questions. Any questions? Okay, let's go on. So patents are valuable. So for example, there's a speed dating patent, which I'm pretty sure was bought by speeddating.com because I was representing someone who was trying to sell his patent only to find that someone else had issued a patent before him for the same concept of connecting two people together in a computer for a limited amount of time, disconnecting them, finding out if they want to meet again, a video again, and arranging it. That sold for at least 6 figures, plus royalties and everything else. So it's valuable because the government, I like to explain the patent system like a mafia. The government controls its territory. The reason why a patent office in the US is better than a patent office in New Jersey is its greater territory. In this territory, government is a monopoly. it can redistribute wealth, and it can take away your liberty, it can grant your liberty. And what intellectual property is doing, it's basically saying, we have a monopoly. We control the courts. We set the rules. You want to play in there? You want our protection? Pay the government some nice money, some nice fees, and in exchange for those protection fees, you get a limited duration monopoly of your own, or trademark. If you keep paying, you get protection forever. Copyrights, I think of more as like the librarian realm. You just pay a small fee and it's good for your life plus. They're not as interested in making money. They're interested in protecting, showing those artistic works and protecting literature and so forth. So that's basically the system, And then each country has their own mafia. They control this territory. You want protection in the next block over? Well, that's outside the U.S. border. You're now going to pay Canada a fee. You want protection over there. And they work with each other. They say, okay, fine. You file the United States Mafia, then you have 1 year from the time you file the United States Mafia to file the Canadian Mafia. And then they work out all these deals with each other, and you can do that in 181 countries, as we'll get to. So, when you patent, you get exclusive use of your invention. Some people, you won't even find out they were planning on copying you because they don't exist. Because they'll go on and do something else. I did research on Kensington locks once. They put these locks on the laptops. They patent that thing up the wazoo. Nobody's going in that market and been selling locks unless they're licensing from Kensington, because they have 15 different patents on all different aspects of this little hole in a laptop, including the size and shape and the way the lock latches in, everything. If you see a computer lock, it's either sold or licensed from Kensington, or infringing. Investors, you want money? Show them you got protection. No one's giving their money to someone who's not going to be able to make it. You got protection, it shows you much more likely to make it, it shows you much more serious. Establishes your brand as being original and genuine. You can license it to others. You can't make the sales, but someone else can. Sell it to them or license to them, collect your royalties. You can sue infringers, and you can stop infringing goods at the border. So even if you only file in the U.S., you don't file in China, which is where the biggest number of knockoffs are coming from, you tell customs, and you can register it with customs, actually, a trademark or a patent. Copyright, I believe you can as well. And that's it. They'll look for it. They won't let it in the country. Questions? Yes?
If any, what kind of protection does a provisional patent give?
Okay, I'm going to get to that. I have a whole slide proving that. Yes?
How much can you rely on customs to actually be the filter to get your stuff, prevent your stuff from coming in?
I know they're definitely very active with it because I've dealt with them on a couple occasions. I once had an hour-and-a-half conference with a customs agent in Michigan over an issue where things were being imported that were trademark infringement, and I've just gotten calls out of the blue that, we wanted to make sure this is from your client because I look up in the trademark database and it's not from somebody else. We want to make sure these are valid goods. If you know, the more information you know, the better. If you can tell them, because there's custom agents all over the borders, so if you can tell them a specific port, like I was able to say Dearborn, Michigan, where the port was over there, there's 5 ports of Michigan, I found that out. Who knew? So, if you're able to tell them where it is, they're able to more localize it, and they're able to more, as opposed to a general database, they'll put it there and put it more up front. But they are very active in it, but they can't look at everything. There's a ton of crates going in and out, including people in them. They don't find some of those. So, they're not going to find everything, but they are definitely very active, and the United States government is probably the most concerned about protecting intellectual property rights and preventing piracy and stuff compared to the rest of the world. I mean, you just compare it to certain like other countries where I've been to. You go into any store and it's wall-to-wall bootleg CDs and videos that are just, it looks the same when you open it, it's clearly like a copy that they put on a CD and they're selling movies for $1. In this country you don't see that, and that's because there's tremendous amounts of protection of intellectual property here. I think I thought I saw something.
Right.
Saw movement. Yes.
I was just curious, what percentage of your clients do you find come to you looking for a patent, not because they have an invention that they want to sell in the market, but because they have an invention that they want to patent and protect and then go after other people who are potentially infringing it through litigation?
don't think I've had one like that.
Oh, really?
I mean, what you're referring to, I think, is like a patent troll.
Yeah.
Yeah, so what a patent troll is they get this legally protected right. They get a patent, and then based on the fact that they have this patent and they're actually doing it, they wait for someone else to do it so they can sue them. And it does happen, and it's totally legitimate if they're really the first ones. And there are in some other countries, in Northern Africa, believe it or not, I forget which one. There's one for the French-speaking countries and for the English-speaking countries in Africa. One of those, it requires actual use in one of the member states to keep the patent, but that's the only place in the world I know that happens. But personally, I've dealt with it on the receiving end. I've dealt with someone who's really trying to seek a license, acting like where my client was infringing, and found out he was just trying to seek a license. But personally, I don't see it. I don't know how big it is, but personally, I don't have clients that do that. Usually, my clients are the ones that it's for their business. They want to predict the business that they're actually doing something. They might actually do it, but it's not their intent at the beginning is usually to do it. Or it might be to seek a license, but it's not that they're going to try and sue someone for copying them. It's that they want to go to a company and say, hey, I got this great idea. I want a license. Do you get royalties? So that's really what I see.
Quick question. We hear, for example, I was reading something in the Wall Street Journal about how these icicles, these Christmas tree lights,
Yeah.
and these people who had a patent on it did not even attempt to enforce it because, the Chinese goods just came in and they couldn't do anything about it.
Enforcement's expensive. They might not have thought it was worth it.
So if you could go to the government and
Yeah.
get it enforced through the
Yeah.
borders, why can't you do that? Why is that?
They can. I think they should. I mean,
Okay.
what do we tell you? I'm an intellectual property attorney. Of course I think they should protect their intellectual property. They can do that. They can get in at the border. Or maybe, I don't know, I don't know the specific case. Is it infringing? Was it not? It depends on the claim language. Like what I went through on the example patent, depends exactly what's claimed. So are they getting around it? A lot of times not. A lot of times in China they're just totally knocking it off. They don't even change anything. So in that case, yeah. I mean, they can take them to court, they go to customs, they can get they can stop the payment processor, they can get PayPal to stop sending them money if people are buying it from the US, paying them in China, whatever the case might be. Yes?
Just a quick verification. So they say by filing a patent or trademark, something intellectual property, you're limited to protecting the item within the domain of the United States. So if there was a knockoff product, let's say in China, you can prevent them from importing the product or providing the service in the United States, but that's the extent of it.
Well, you could also file in China. You can file in the Chinese patent office as well. I'm going to get to that. I have a whole slide on foreign filing, and then let me discuss it there. Okay, so let's move on. Okay, preparing to file a patent. So this is what goes into a patent application. We're getting a lot of worldwide questions. This is what goes into a patent application pretty much around the world. The practice is different from place to place, but what goes into a patent is pretty standard around the world. So before you file the patent, in your preparation, what you've got is a trade secret. You generally want to keep that trade secret. You don't want to be shooting your mouth off. First rule of law is keep your mouth shut. So before you file a patent, you develop it, you test it, keep it confidential, you're keeping it as a trade secret, and the U.S. will give you a 1-year grace period to file after making it public. So in other words, I tell people do not rely on this. If you have to, you have to, but it's not a good idea, because you don't want to have an argument over who's the inventor, who came up with it first, all that type of thing. And further, if you're filing around the world, you file in Europe, there's absolutely no grace period. You disclose it to somebody, that's it, you're done. And as I just alluded to, it's going to create issues in litigation. You go to sue, oh, here's this public disclosure. You say, oh no, that was by my sales associate who worked for me. No, it's not proven. Now you're going to go back, this guy, meanwhile, you fired a year later, and you're going to go back again and testify in court that really he was working for you and it was your idea. It's just better not to have to go there. Get the first thing filed, don't create a paper trail, except for your own paper trail that you control. Should clarify. You want to create a paper trail, but you want to have your total control of the paper trail, not things out in public. U.S. law in 2013, this is actually signed into law. 2013 is changing to a first-to-file system. That means right now, till 2013, I've actually done this. I had a patent just issued, simultaneous film roll camera. He takes these old 70mm cameras, put two 35mm rolls in it, winds it up, and shoots on the two films at once. Just got the patent for that. Guy in Flickr had the pictures. He put them up there, and same concept. But it was before the filing date. So what I actually did was to submitted the first draft of the patent application with a novelty search. I don't remember what. I said, look, here's the search I did. Here's the pictures he sent me. Here's the emails that are dated. He was in possession of the invention first. I got the patent that way because he got it for this guy who posted the same thing on Flickr. So that's all changing. And I had this whole conversation with the examiners. I don't know what we do with this once the law changes. You know, probably wouldn't get the patent. So I happen to like the first to invent system. I think it's fair, but you know, I'm one guy in a whole country setting these laws. So it's going to change to the first to file system in 2013. And once we have the first to file system, you're going to want that early filing date. Which will bring us to maintaining confidentiality. So ways to maintain confidentiality. You can have a formal confidentiality agreement. If you're dealing with an attorney, you have attorney-client privilege. You go to a criminal lawyer. It's funny, no one goes to a criminal lawyer and says to him, I just shot a man, but before I tell you the details, I need you to sign a confidentiality agreement. Lawyer cannot go and turn you in. Unless you're a clear and present danger and you're about to shoot more people, he can't go and turn you in for that. He's there to represent you. They come to a patent attorney, they say, I need you to sign a confidentiality agreement first. So I have duties of confidentiality in my engagement agreement. But the truth be told, it's not strictly speaking necessary because I've got a duty of confidentiality to the law anyway. I spent, should my parents spent, a ton of money on undergrad and law school, and I got to take all these tests, the SATs and the LSATs and the bar and the patent bar and study for all these exams. I'm not losing all this and chance of going to jail because you think your idea is making $10 million. You very well might, but you're the guy digging the gold in California, I'm the guy selling you the shovel. I do very well selling shovels. So that's basically my role here. I sell you shovels, you dig for gold, you may get nothing, I still get my cut on the shovel, or you may become a lot richer than me. Percentage-wise, I have to like my job. So that's basically the system. And when you do talk to people, and I tell this even to people who call me on the phone because I don't want to know, I don't want to be sued because they say, oh, I patented for someone else or whatever. Talk generally, not specifically. Do you want to invest in a better mousetrap? Don't tell me, oh, this is a, whatever it is. This is a carbon fiber mousetrap that cuts off the mouse's head as it goes across. Don't tell me that detail. Tell me it's a better mousetrap. That's all I need to know. And then I can give you, estimate of price and go from there. And keep records to determine misappropriation, so you know if someone else goes and files a patent, it wasn't theirs. They start suing you because you didn't file a patent they did, or whatever the case might be. Data conception, due diligence to show when you got it. Some of this, again, is changing in 2013, but keeping records is always a good idea. Well, I should say always. In this case, it's a very good idea. All right. When is an invention patentable? It's got to be useful, which is the easiest requirement to meet. Kills the weeds. It helps the weeds grow. That's useful. Yeah, that's an easy requirement. I've never seen an examiner, actually I have, but only in really badly filed applications. It's very rare a patent examiner will say this isn't useful. It's a subjective test. Anyone can claim anything's useful. Novel. No one has sent messages as a bunch of dots and dashes before. That's new. I never thought of using my phone plan to authenticate my bid on an auction. That's not obvious. It's not necessarily, any of the moving parts, but the whole method is not obvious. So that is considered new and not obvious and useful. It's all the requirements. That is something patentable. Yes?
Can you patent a toy?
Yes, absolutely. Again, it depends what it is. As long as it has a feature which is new and unobvious, and that's what I'm patenting. If not, I can go to design patents, which hopefully is the next slide. Yes, the next slide. A toy you could also patent as a design patent. The ornamental design for an article of manufacture. And these only last 14 years. These are relatively simple to get. They're relatively cheap. The protection is a lot less than a utility patent. So oftentimes I tell people file a utility, file a design if you can. Throw it in for a little bit more money and give you a little bit extra because it protects the look of a functional object. So that goes back to my mouse example. This is a sideways mouse. and they would protect the look of this functional object. And the utility is, I put almost anything, new and obvious under the sun made by man. So anything which is new, it has a new function, but it has to be a function made by man. So it cannot be law of nature, abstract, or natural phenomena. So in other words, I can't patent ball lightning, that's a natural phenomenon, but I could patent the method of creating ball lightning. Ball lightning is, it's been videotaped very infrequently. I think there's now some new literature on how it's formed. But it's basically like a ball of light that rolls around and then disappears. So it's called ball lightning, one of these crazy natural phenomena we have in this world. So, and those last, the utility patent lasts 20 years. Nobody ever asked me about this question. That's probably because I'm in Hoboken, New Jersey, or I speak in places like this where you look out and it's like, there's some trees, but there's houses and industry all over. But there is such a thing called plant patents. My associate in Pennsylvania, who I work with, she gets more farm equipment and stuff like that. But in this area of New Jersey, nobody asks me about plant patents. Nobody even mentions it. But you can actually patent a new strain or a new breed of patents. And this is just more interesting than anything else. You provide a picture, you provide a description of what you did to make it, and what the mix is and what it looks like, and that's it. Your strain of plant is patented. Don't ask me what determines the plant patents because I don't know. All right. What is patentable? Process. So this is just deeper review of the previous slide. Method of routing calls to an IP phone would be a process. Machine is a device that does it. Your Vonage box would be patentable. Your method manufacturer, a black box having punched out holes for at least one phone, one network port. So that is the actual manufactured product. Composition of matter, mixture of 95% synthetic fiber, 5% steel wool, forming whatever it is. Born as titanium is what I'm working on now. Or any combination of above. So as you can see, patents are broad. They're limited in term, but they're broadly protectable as long as you really have something that we can go and say, aha, look at that feature. That's something I learned from the former head of AT&T Patent Division. When he partially trained me, and when I talked to clients with him, he would actually say to them, what's the gee whiz of the invention? What's the gee whiz? What's the thing that I'm going to look at and say, oh, look at that. That's what's wonderful about this. That's what we're going to try and protect. There are questions? Yes.
Is there an example of something encountered that you would call too abstract?
We used to get them constantly. The Bilski case is a Supreme Court case on business methods. So between the time the Court of Appeals for the Federal Circuit had it and the Supreme Court had it, they reject everything as being abstract. So for example, not everything, I should say everything, but any sort of business method patents, they're rejecting them left and right. So they would, if you wrote, it used to be a method of using a computer-readable storage medium. You know, anything that stores data that a computer can read. Then they started rejecting all those as abstract. They said, well, I don't know what that is, that could be anything, and so on and so forth. So now the way we write it is a processor configured to carry out steps including A, B, C, and D. That they consider okay. Every 5 to 10 years, it's a moving area of law, and every 5 to 10 years they change the way it has to be written to not be considered abstract. It's actually a very big deal with business method patents, the type of stuff you expect to come out of NJ Tech. You know, in terms of how you write them. But it's, in my opinion, it comes down to just the wording. How do you write the language? You know, it was, in Bilski case, it looked like it was going to severely limit it, and then the economy crashed. Patent filings went way down. There was the patent office was having budgetary problems. And all of a sudden, the Supreme Court says, that's not the only test, there's other ways to do it, and the patent office opened back up and got more liberal again. So, you know, there's, I'm getting off tangent, but a lot of this is politics and everything else, and who's in office, and who's the director, and what they're doing. Right now, the director, in my opinion, is very good. David Kapos, he's a former head of patents at IBM, and he's trying to streamline the process. He's giving examiners not enough time to examine patents right now. I'm hearing a lot of that from examiners. So they're not doing as good a job, but I am getting a lot more allowances, and it's a lot more making sense what you can and can't get through. You have to go to a patent attorney who's in the field and knows how to draft a claim is what it comes down to. It's not an area of law you can do yourself. But anyway, I don't know what the original question was anymore, but I believe there's another question over here.
Software. Is it a copyright or
Software, you can copyright the code, you can copyright the look of the end product, and you can patent it if there's a new and obvious method that's being carried out. So, you know, my auction patent, there's a reason I brought that one up, because I thought it would be most relevant for this group. But the auction patent, using the phone to auction, I mean, really, that's a piece of software he's running. A piece of software combined with Billboard. You know, but even with other things, like the piece of software itself, I can't patent the software directly, but I can patent the method of doing steps A, B, C, and D, as long as those steps in combination are new and obvious. And that's how we protect software.
okay, suppose there's a software already and you want to, you know, create another software using the same idea. Of course, that is change it. So how would you have to go to a patent attorney to find out what is patented in that software? What has been patented by the company?
Well, that's for infringement issues. In order to infringe, I have to not be carrying out every step of what they have in any given claim. And then that would be infringing. But definitely go to a patent attorney just to understand how to read the claim, because there's also doctrine of equivalence, the equivalent to what's written there. It can get crazy. That in terms of infringement. In terms of patenting it, if this software is already out there and I want to patent the software, I need a new and an obvious way of carrying it out. There's got to be something new and an obvious over that other one in order to patent it myself. So it's going to have to be something different than what the previous guy's doing. All right. Any other questions? Okay. Let's move on. Wow. Okay, filing a patent. All right, we're getting towards the end. I'm on step 5. First to invent system. This is what we have right now. Until 2013, you can swear behind a reference up to 1 year before the filing date. So I file 1/1/2012. I can swear behind back to 1/1/2011. Examiner cites a reference dated 1/1/2011. Well, I'm not sure about that exactly, but he cites something in June 2011. I can say as the first inventor, I submit evidence, and I can still get the patent. 2013, there's still going to be a 1-year grace period from the time of your first public disclosure until filing. This is actually identical to Canada and I think Australia's rule. But only for your own disclosure, not for other people. Other people disclose it before you in 2013, you're done. Guy has it on Flickr beforehand, the concept that I'm trying to patent, done. Till law changes, keep records, proof, conception, diligence, notebooks, should be dated and witnessed. I should cross that out and write backups should be properly dated and in a secure medium that can't readily be edited, or whatever it might be. Brainstorming meetings should be documented. In other words, document everything to show you're the inventor. Now, Aaron's question, provisional application. When pressed for time to disclose an invention, or you're just testing the waters. I'm not a big fan of provisionals because you have 1 year to convert it to a utility application. It must be enabling. Now, the problem with these is, it's true, all you have to do is enable them to carry out your invention. He just has to describe how it works, that's it, you can throw it at the wall. It's never examined, it buys you 1 year of time. The reason I'm not a big fan is, for the most part, the reason they're being filed is we're doing a less good job. We're not sure, we don't want to pay, so let's just throw something there and get some protection. If that's what you have to do, you know, you want something because you're disclosed to one person, then drop it after if he doesn't take it, that might be okay. But really, it should be as good as a non-provisional. You should have everything in there because you don't want to have a problem. You don't want to say, oh, you weren't really in possession of the invention. Oh, look at this added feature you put in only in the non-provisional. You can't claim back to that date for this, that type of thing. So really, it's in my mind, it's best just to do the non-provisional. It's best just to do it properly, do it fully, do it once, do it right. That may change in 2013. The reason I say it may change is because it becomes a first-to-file system. So at that point, it might be a good idea. Like, I'm contemplating, as soon as I do a novelty search, I take whatever inventor disclosure I had in the novelty search, and I'm going to offer for a couple $100. I'll just file it as a provisional application, and then we'll get to work on your non-provisional, just to make sure we have that filing date. But, I don't know, we'll see how that plays out. We got some time to worry about that. And then what we do is a novelty search. Inventor gives me a disclosure. of what their invention is. Depending on what it is. You can just tell it to me, but again, I recommend having some sort of written dated record at least, just for your own sake. They'll tell me what the concept is. They'll give me a prototype. They'll give me whatever it is, screenshots, whatever the case might be, drawings of a product, as long as I can understand it well enough to search it. And what we're going to do is make sure that your concept is new and unobvious. Again, that's what you need. And we can search the U.S. Patent Office. We look at, my search is, my most common search by far is I search issued U.S. patents. I find the class and subclass, so the class might be surgery and the subclass is knee and then prosthetic or whatever it is. And I look at those references, and then I might also do some keyword searching to make sure I've covered everything. And patent searches, you can pay between $200 and $5,000 on a patent search. The $200 is somebody's going to go into Google Patents, type in a few words. He's going to download the first 12 patents and shovel them at you. $5,000 search is probably overpriced unless he's doing worldwide. And in between is what I standardly do is I find the class and subclass. I look through the most relevant references there, and I do some keyword searching, general or within the broader class, to make sure I haven't missed anything. And I'll give you a patentability opinion, which will be a report of these are the features I've found, these is what features that you would claim in your patent, this is how I search, and these are the closest references that have features A, B, and C, but this one lacks D, this is A, B, and D, lacks C, but hopefully it's not obvious to combine. Whatever the case might be, that's a standard patent search. Alright, so we're going to determine scope of patentability. So in other words, if your invention is here, here's all the prior art, the sea of prior art. Here's every other entrepreneurial meeting. Here's what Mission 50 does. Kind of overlaps there, but it's got some new features. Then we're going to claim this area. Now, on the other hand, you could be anywhere on this. If you're in the middle of the prior art, forget it. Go find something else to do. If you're all the way out here, claim broader. Instead of your invention, even if your invention is this, you might be able to claim this. Let's get as broad as we can. So it's going to familiarize us, me and you, with the existing technology, and we're going to know what the competition is doing. Not only that, I might look at the competition's patents and be like, this is how it's being protected. I don't know every area of, technology. Nobody can. So if you come to me with, hey, I don't know, a new method of doing the ear implant, and I see that the other patents are out there. What the other patents for ear implants do, I'm going to see a way of claiming it, a way of protecting it. So that's the whole purpose of a search. I guess I'm going to pause here. Are there any questions? Okay, let's move on. So then we prepare the patent. So I get the disclosure, telephone, email, in person, Skype a lot of times. And I'll give you the novelty search with the opinion of patentability. Draft the event, draft the claims, you get up to 20 included before they start charging you more fees, and a complete specification. Some of these aren't required, but they're generally in applications. A background of the invention, where I try and sell it to the examiner and say what this is doing new over everything else, and so someone who's picking up and reading it can figure out what they're reading. A summary of the invention, that's what courts read because they want to read something closer to English on the claims. Detailed description of the invention and so forth. And the drawings, draftsman and patent practitioner, whoever else, if there are flowcharts, I do flowcharts myself, but I use a draftsman when I need him to actually draw things, or you can provide drawings in black and white line art goes in patents. No color yet. And then we get to the patent office. So, number 6, at the patent office. Submit the complete application. Right now it's $530 for a base fee for a small entity. You have less than 500 employees. You have 20 claims, up to 3 independent claims, being 3 that stand on their own. And that's filing, search, examination, it comes out to $530. Submit a declaration signed by the inventors. We swear we invented this. We affirm that we invented this. And this is ours, and under penalty of criminal penalties, I'm not lying, and so forth. Submit an information disclosure statement. The way the United States works, and the way Australia used to work, my Australian associate tells me it's no longer required in Australia, you have to submit everything that you know about which is relevant to the examination of your patent. It's not supposed to be an adversarial proceeding. You're supposed, it becomes that way often, but you're supposed to work with the examiner and you're supposed to say, this is what I know, these are the claims I think are patentable. He does his own search, he says, this is what I know, and then we might talk to him, we'll have an examiner interview, we have responses on paper, to keep paper record, and we determine what's patentable. It's an absolute duty to disclose what we know. And assignment documents if you're assigning rights to the company. So from you to your company or whatever it is. And tangentially, people who are working for you, in their hiring agreement, there should be something that says anything that they do is owned by the company, on behalf of the company, they will assign to you. Yes?
That was my question. If you have an idea and you hire someone to figure out how to make it,
then that's a work for hire agreement. And I've seen a lot of these agreements need some work. It's highly advisable to use an intellectual property attorney in drafting these agreements because regular attorneys aren't necessarily versed in this area. You want to make sure that the agreement says that the people who are working on it, it's a work for hire arrangement. You own anything, any of the work product that they do that you're paying them for, and if they come up with anything new that that is owned by you, and even if they are the inventor, you might have to put them down as inventor in a patent application because they come up with some new concept, and now you add their name or whatever because by law you have to, but they have to assign the rights to you or your company.
if they discovered it in the creation of your product.
Yes.
Wow. Okay.
I mean, a more classic example is if you're having someone doing chemical lab testing. You know, it doesn't happen as much with, you know, tech stuff. It could, but you know, chemical research, and they discover this new way. I mean, my grandfather, he has patents in his name that I looked up and spoke to him about, and he came up with I forgot what it was offhand, but a way of dyeing something. Chemical patents used to be the big thing 50 years ago. Today it's all business method. It used to be all chemical. And he came up with this new method of whatever it was, dyeing something, or cleaning agent, or whatever it was. And he's the inventor. But he comes up with this new invention. The company wants to own it. They paid him to do the research. They paid him some royalties. He said it wasn't nearly as much as he should have gotten.
But they owned it. The company owned it.
Yeah, but the company owns it. So you want to make sure they come up with stuff, it's owned by the company. And unlike Europe, the person working for you is presumed to be owned by the company. The company files the application. Here, inventors file the application. They have to sign declarations for each and every one. And each and every patent, it has to be assigned separately. So you have this contract that says they will assign them. And if they don't, well, it can be a royal pain, but contractually now, this is now state law, not federal, contractually they have to assign the rights to the company. They have to sign that document.
But they do the work of filing the patent?
Usually the company would do the work and pay for it.
So I hire the guy.
And you
he
just
comes
make
up
sure you
with
have the
thing.
rights to which filing.
Okay, so that's part of your contract.
Yeah, it's part of a work for hire contract.
Okay.
My personal work for hire contracts is every work for hire contract I draft.
Okay.
Yes.
If you're a consulting company,
Yes.
and you are working under work for hire, and you have your own ideas even prior or during it, that's separate from those ideas?
You better keep it
Exactly.
separate, not model it. Don't use their computers. You know, don't do it on time when they're paying you. You create a litigation issue. So, you know, you're doing it fully at home, and I mean, I've seen some contracts that cover anything you do anywhere. I'm not so sure those are enforceable, because if you do it at home, it has nothing to do with the company, it's your own idea. But it also depends on how closely related.
If you're an external consulting company, like not working.
It depends on your relationship. How many consulting companies do they have? How many clients do you have? If they're one of 50 clients, then, you know, hopefully they're the only, you're not going to have conflict of interest. They're your only client for whatever it is, developing iPhone applications in the field of personal health. I don't know about the medical thing today, but and your other ones are developing iPhone applications in the field of web browsing. So then there's not going to be too much of a problem. And if you come up with something on your own that it's this new children's toy, hey, there's not going to be a problem. There's no overlap there. But when you start muddling the waters, oh, well, even if you didn't do it on our time, you got the concept based on our disclosure, we have this thing that you decide rights, you know, it can get tricky. But if you get to that point, consult an attorney.
Just thought there's big enough difference in between the work you're doing for them and...
Generally speaking, it's not legal advice, don't sue me if it
yeah.
doesn't work out, but for the specific facts of what happens, pay for consultation.
Right.
You know, okay, any other questions? Yes.
About the IDS, it's include a patent application, or you have to file it
You can file it at the time of filing. Personally, my practice is I have so much to worry about with filing. I usually file them every 4 months or so. I file them in batches. Yeah, I mean, just that's how I do it. But it has to be filed before examination. Examination comes in 1 to 2 years, as we're going to get to. There's an extra fee if you file it late, and your patent becomes unenforceable if you never file them.
Before the first action,
Before the first office action, yes, which I'm going to get to. Yes, you ask Kendall about it. He does work for me, and he prepares my information disclosure statements. It's the first thing I have to do. Okay, so first office action on the merits, sometimes abbreviated as FOAM. Examiner reviews the prior art and typically rejects. It's kind of like dealing with Horizon. Horizon is my healthcare company. So, and I have no problem saying this in a public and recorded video. You submit a claim, they reject it. You go back, they reject it, you go back and forth until they finally agree to pay something and then get spelling my daughter's name wrong and still don't pay some of it. So eventually they get it right. The patent office is actually better than that. They spell the names right. Don't reject because there's one letter wrong in your daughter's name. Okay, anyway. Healthcare is a different issue, I'll be happy to talk to it after. It's messed up in this country. The patent system is doing much better than the healthcare system. Alright, anyway. 35 USC 101. There's no utility, it's abstract. I think we killed that issue, so 102, it exists in a single piece of prior art. In other words, your camera roll thing is the same thing you disclosed here. Every single feature is in that, your claim is no good. 103, I can smash together two references and it's obvious. I smashed together this guy's pictures and I smashed together this camera from 50 years ago and I come with your idea. It's obvious to put the two together and do your invention. You can agree, you can disagree, it's subjective. Overcoming based on, that's not obvious, usually doesn't work. You have to overcome based on, that feature is not shown. That feature is really not shown here, or if I combine the two features it would be non-functional or something like that. 102 rejections are actually usually easier to get over 103, because 103 they start combining 4 different references together to find every feature. And you gotta argue that, where 102, hey, there's one feature different, that's it. Or you amend the claims to get around these. Alright, 35 USC 1012. Enablement, you haven't particularly told the public how to carry out your invention, or inadequate disclosure is the same idea. You missed something. I don't know how to carry out your invention. I don't know what you mean by that term. If it's really bad, you're stuck. Usually it just means we change the wording in the claim language to use words that are in your specification. Or if I'm reviewing ones that other people have drafted, you can find some words and you find ways to fix it up. That type of thing. I mean, I've taken over applications from other people, and although I obviously have a self-interest in this, do not file your own patent application. Unless you've gone through the process a couple times, or you're an engineer and you start drafting you start having experience with these, things that people file on their own are generally, I sit there fixing them up. And you're not going to end up with the best result at the end because you're kind of patching it together to make it work. Provisional, you might file yourself. I don't think it's a great idea either, but there's a possibility to do it. You can do that without, as long as you don't harm yourself and start talking negatively about your things. You basically put whatever you want in provisional. But non-provisional is it's a technical document. It's highly technical and needs to be done professionally. Yes, sir.
Can you change anything between provisional and the actual patent? If you
Yes.
start working on it and you realize,
Absolutely. But you will get protection back to your non-provisional filing date for the things that are new in your non-provisional, and you get protection back to your provisional filing date for the things that are in your provisional.
What if in the provisional they were just less well written, for example?
It would probably
you
be
did that yourself
protectable.
and then consulted.
Yeah, it would probably be protectable.
Okay.
I mean, what you could do is write it and just have an attorney look over it and comment and, do an hour's worth of time on that or whatever, that type of thing. Alright, then, once we get our rejection, we have an examiner interview, written response to the office action, and amendments, or, these are various possibilities. Examiner interview, you can do it in person. Some attorneys do that. It's obviously more expensive because you got to pay someone to travel to Arlington, Virginia. But I do them on the phone. I call them up. You talk to them. Statistically, the allowance rate is much higher for those that do examiner interviews than those that just respond on paper. I'm a big believer in it. There's a lot more you can get done by talking to a person, explaining them, and talking about their day and their kids and everything else, and you work it out. you know? And then we can have a written response, and we can amend the claims. Other things that we can do, you might have a restriction requirement where you get more than one invention. Nowadays, these are getting more popular. They restrict everything. You have a method, and you have a device and a method of using it. They say, oh, those are 2 different inventions. So you have to choose which one to examine. I have actually started, because I think they've been getting crazier, I have actually argued against these, that there's no reason to restrict. There has to be a substantial burden, a substantial search burden on the examiner to examine all the claims at once for them to do this. And then, if that happens, you file a divisional, you pay the government more fees, the examiner gets twice the amount of time to review, and you file a divisional for the second set of claims on the same application. Continuations, it's rejected twice, you get a final rejection, you can continue, you file another fee, you provide more arguments, it happens. I mean, my associate Cheryl, who works for me, she used to be a patent examiner. She said sometimes what would happen is they would do a first office action, it wouldn't be so good, and the person would come back, and half the time people don't respond to office actions. They file, you don't hear from them, so no one looks over it at that point, but meaning none of their superiors look over it. And then you come back, you'd argue against it, and then they'd give you the real rejection, it will be fine. And then you're forced to file a continuation because now you have a good rejection. So hopefully it's not always like that, but you know, it can be that sadistic. And you can also appeal. I've done this too. There's now a pre-appeal process. The examiner just doesn't get it. His rejection is nonsensical. You talk to him in the examiner interview. He's not budging. Appeal it. You want someone else to look at it. You can actually petition to have him removed as examiner, all these other things. I've never gone that far. But you appeal. The problem with appealing is, though, you'll be right. Generally, 80% of the time, it goes back to the examiner. Now he's not too happy with you, and now he gives you a real good rejection and really spends some time on it. And then you got to argue that. And we can do foreign filing. Okay, so I'll pause after foreign filing for questions because I think we'll have questions on that. So the U.S. patent protects you only in the U.S. You pay the U.S. mafia, you haven't paid the Canadian mafia. Well, what we can do is each mafia has a treaty with others. There's 181 countries and entities. European Patent Office, a RIPO, is the English or French-speaking countries in Africa. OAPI is the other one for Africa. I think OAPI is French. Yeah, and the other one's English. And you have 1 year from you filing in the U.S. to file in other countries. Each country has its own rules, its own fees. You will pay me for my services. You will pay the Canadian or whatever the foreign associate for his services. You will pay the foreign government fees. And this is generally the way it works because you don't want what happens in one patent to affect your rights in other countries. So if you're filing in multiple countries, and I will openly say it can get very expensive filing in many countries, so choose countries wisely where you're really going to sell. And what we will do is, if we get a new reference, then I've already looked at the application. I'm most familiar with it because I drafted it. So I generally will give instructions to the foreign associate. This is how to argue, this is how to amend the claims, and then he does on paper what's needed for the patent practice in that country, and vice versa. If I get a foreign client, I'm filing on behalf of firms that I work with in other countries, then I'll file their patent application, I'll send him the rejection, and he'll give me instructions, here's what to do, and then I take those arguments and I write it up properly for U.S. practice, or whatever it is. Major entities, EPO, Europe, OAPI, Africa, which isn't used too much, but I keep mentioning, Canada, China, Japan, Australia. You can file directly in each country or via PCT channels. I'm not going to that today, but basically that gives you 30 months from your earliest filing date instead of 12 months until you enter the country, the individual country. And eventually you get this thing, you get an issued patent. I should actually draw one here. But you get the patent, which has the whole thing, which you've worked long and hard for, and now you can put this on your wall as a status symbol or go out and sue people and get money, which is really the more important thing. All right, to review. Inventor disclosure. Novelty search, then tell me what you got. I'll tell you if it's worth searching. We'll find something, we'll search it, draft the application, we file it, examination at the patent office right down here. We go back and forth the patent office till we get it issued. Sometimes it is right away, you know, like every now and then Horizon pays a claim right away. Every now and then you get a patent through the patent office right away, and eventually you get a patent, and the fund doesn't stop. You pay maintenance fees, 4th, 8th, and 12th year of the life of the patent to keep it valid. Although this, of course, again, has the benefit of money to the government. Generally, any problem you have with the patent can be fixed with money. That was the answer on the exam, where if you didn't know what was the answer choice in the patent exam, find the one that includes pay a fee. So, in order to keep the patent alive, you pay the 4th, 8th, and 12th year. You can keep it alive for 20 years for utility patent. Design patents have no fees. They're alive 14 years no matter what. The reason for this is actually, there actually is a very positive reason for this. If you are a wannabe troll, you patent something, you file it, you never use it, and after 4 years, you're still not using it, well, if it's not worth it to you to pay the couple $100 in fees, let someone else use it. Now it's open to the public. Anyone else can use it. They don't have to wait 20 years, they wait 4 years. So that's the whole purpose of that. Oh, I said I'd pause after 4 and finally I didn't. So why don't I take questions here? Yes?
Is this example I'm going to give, is this a design patent?
Yes.
There's something that exists like a snow cone making machine. And
Yeah.
then somebody had an idea to make that for kids. So it's little, it's cute,
Yeah.
it's different, but it's using the same technology. So for the person to create the snow cone making
If
machine
it's
for
the same
kids,
thing, if it's carrying out the same method, the same process, looks the same, but it's smaller,
looks to look really different because it's,
okay. Well,
but it might be using the same.
if it looks different, then you might have a design patent. Yeah, it would be a design patent if it looks different. If it's functionally the same, not a utility patent. But if it's functionally different, then there's to be a utility patent. I mean, the inner workings.
If they had a patent on it, like if the snow cone machine had a patent on it, would
Yes.
you be able to remake that for a different, for this different market for kids and this?
If it's well, probably not. It has to be a new and an obvious use. So, for example, Tylenol as a weed killer would probably be patentable. No, it's not because I just disclosed it as my idea. But Tylenol as a weed killer would be patentable because it's a new and an obvious use. But Tylenol to give to kids as opposed to give to adults, or to give to, I'd say, give to your beagle instead of give to your kids. That probably wouldn't be unobvious. It might be new, but it's not unobvious.
So would that be a case to talk to a patent lawyer? Like, is this?
Everything's a case to talk to a patent lawyer.
But like, is it going to be worth it to me to create this modification?
That I can't tell you. Would you make money on it? It only comes down to why you're doing this, to make money.
Right.
You're filing a patent because it helps you make money. The government wants you to file it to, help advance society and have a good functioning economy. So, if you're going to make money on it, yeah. I mean, that's the ultimate question.
But I mean, could they sue you because they already they have a patent on this?
Assuming they have a patent, it's possible. It's possible if you're infringing upon their patent, even if your thing is patentable, it still could be infringing upon a previous patent. So, I mean, that's still a problem. I mean, that's the thing to, talk to a patent attorney. Preferably paying them for a consultation. All right. Yes.
Let's say you have, let's say you want to make an improvement on something that isn't really worth reinventing the wheel with.
Yeah.
Is it possible to maybe what I'm trying to ask is can you license a patent that already exists and then just maybe spin off of that, or how would you do something like that?
Like what following? Like if you want.
Like if you have an invention, but it's not really an invention; it's more like an improvement. It's something that already exists.
Yeah.
If someone comes up to you with that kind of thing, what do you usually say? Like, let's just try to find a way to make it.
Oh yeah, we try to work around it. I mean, practically speaking, most people don't come. I'd say, it depends. Practically speaking, like individuals might come to you and say, this great idea, this is so wonderful. But businesses will come to you and say, we're selling this product, your patent attorney patented. I don't know if I can speak about this example, but they'll come to you and say, this is what we're selling patented. So as a patent attorney, I look and find a way to protect what they're going to sell anyway. And that's often my job and what I end up doing. Yes?
What is the difference between a patent attorney and an intellectual property?
What they choose to call themselves. Well, actually, no, there could be a big difference. Intellectual property attorney, a lot of people calling themselves intellectual property attorneys do not license with the patent office. They do trademarks or copyrights, and they might say, I'm an intellectual property attorney. It's kind of like someone who does patents kind of, laughs at it a little bit. Like you're calling yourself an intellectual property attorney. Like you don't do real intellectual property. I do real intellectual property. It is real intellectual property, but trademarks and copyrights aren't nearly as complex as patents. And on the other side, you can deal with a patent agent who's not an attorney. He's licensed solely to file patent applications. He can file patent applications, but he can't do contracts, and he can't do licenses, and can't do that sort of thing. And there's even people called themselves patent attorneys who might be litigating patents. But when I say patent attorney, when I refer to myself as patent attorney, I file patents. I mean, I work with firms when they go to litigation. I'm litigating now that I'm working with. But what I do was my bread and butter is filing patent applications. I also file trademarks and copyrights as well. Okay, other questions? All right, let's take from back there. I haven't got.
Excuse me. A couple slides ago, at the bottom, you were discussing actually dealing with the examiner, and you said at one point the examiner might split the patents in two.
That's a restriction requirement.
Restriction requirement. Can you go over that a little bit? And what are the chances that would happen, and how often does it happen?
Okay, I'll tell you the theory what's supposed to happen. If I file a patent application, that includes, it's for a method of world peace and a method of thermonuclear warfare. Those are two different patents. So claims 1 through 10 are on world peace, claims 11 through 20 are thermonuclear warfare. The inventor thinks they're the same thing. I'll bring world peace or thermonuclear warfare because we'll all be dead, no one's fighting. But the patent office will say those are two different inventions. So they'll say you have to choose one. So he chooses the thermonuclear warfare because that's a more colored example. And now he chooses to elect those, and he can go and file a divisional application, a second application, and he says, the second application is the same disclosure, now examine my claims for world peace. So that's basically the way it's supposed to work. What happens practically is you might file something that would be a method of, I don't know why they're all eluding me right now. Okay, the child walking rope thing. The hold-on handle. They're holding on a handle. So I put device claims for the device of the handle, and I had a method of using it, a method of having your kids hold on to the handle and walking with it. So the examiner gave me a restriction and said they're different things because I could use the device as a tie down for my trunk instead of walking with kids. So I got a restriction requirement. So, I mean, that type of thing happens, and then you examine one set of claims, and often what happens is then, after they're done with examination, you say, hey, you know, you've already found all the art for the other one, could you just allow the other one too? And usually, oftentimes they do, and then you get the whole thing. That's basically how restriction requirements work. And it happens, now it can happen whenever you have a device claim and a method claim. You claim a device and a method of use. You may or may not get a restriction. It depends on the examiner, it depends on the art unit, you know, which office you are in, the patent office. Depends on a lot of things. So I try and do things to prevent them, but it happens.
Mm-hmm.
Yeah.
Can you talk about the approximate costs that people should expect for each of these things, including legal fees?
Trademarks start, I mean, personally, I mean, afraid to say this in video because my prices might change when someone's watching the video. Trademarks spend $1,000 for filing, including government fee. If you want a full clearance search, about $1,500 to $2,000. Patent applications, you know, neighborhood of $1,500 for a search, neighborhood of $5,500 to $8,500 for a patent application, you know, depending on complexity. Whole process for a patent application.
You said $8,500?
Yeah. Whole process, you know, depending on what happens in the patent office, could be $10,000 to $20,000 whole process for a patent application, spread out over, you know, a couple of years usually at least. Yes.
For the $8,500, is that one patent or multiple patents that you're filing as a package?
That would be one utility patent.
Okay.
And the design patents are including once you get done with drawings and government fees and lawyer fees. A design patent might be right now it comes out to usually $1,720 altogether, including government fees and stuff for a design patent. But if you're watching this on the video later, this video might be out of date. So, all right.
What
yes.
about a provisional?
I hate that question. The reason I hate that question is it's very open-ended. If you want me to take your disclosure, you know, you want me to take your for stereo, and I take your stereo manual as everything and file it, it might be a few $100 plus $125 government fee. Now, if you want me to draft the whole thing like it's the non-provisional, I put the whole thing together, you know, it could be the whole thing. So I try and prorate it, like what percentage of work am I putting into this compared to the whole thing, and come up with the price. I mean, I usually do flat prices for patent applications, a certain amount of fraud, and the rest time of filing. So, you know, it depends. Yes?
Is there anything that someone who's just starting out could do immediately that's very low cost, or maybe a do-it-yourself solution for a short term to help protect themselves, you know, for when they are ready for the full-blown whatever it is protection, you know, some other IP protection?
Keep quiet and use confidentiality agreements. And yeah, I mean, if you don't want to spend the money, I mean, there's the provisional, but you know, just make sure it's done right.
I guess
done well enough, I should say.
Maybe a better question is, what mistakes do you see commonly made that we should all avoid?
Not spending the money where you should, because in the beginning, when you're a startup, you don't have a lot of money. You know, you got to spread it thin, and there's things that often should be protected that aren't. That then you'll find you're not getting the investor dollars, or worse, you're getting people copying you, knocking you off, and you don't have proper protection. After the fact, it's much harder to then file and get people to stop, and it takes time to obtain this protection, even if you still can. Like trademarks, you can. Copyrights, you can, but your damages are less. Trademarks, you can always file later, but trademark damages, once people are copying you, you gotta get to recall. Much easier. You're in a much better bargaining position. When I write the cease and desist letter to another lawyer, you have a registered trademark, much better arguing position than if you just try to argue, hey, this is too similar to my client's product. That type of thing. Alright, so to conclude, typical timeline utility patent. Search. Suppose we file this in January, or do the search in January. About 2 months later, I'll be able to draft and file your application by about March. Information disclosure about May. Foreign filing if you so choose. Within 1 year, you can delay this fee till here. Office actions, 15 to 50 months. So let's suppose you get one for 2013, which is being a little generous. You might get that issued about 2014. And thank you. That's me. That's my number. Business cards are right here. And let me take a few more questions, and then what we're going to do is I'm going to look up your trademark and your trademark question, and we're going to see how this works in real life on trademark. So do you have any other questions before I go to that? Yes, sir.
For a global application of patents that's hypothetical for utility patent, what would the price be?
What do you mean a global?
Like
All 181 countries?
I'd just say
$1,000,000?
like 7 or 8 countries, like the most in Europe, Asia, and in the Americas.
Japan is particularly expensive. Europe is also expensive, come to think of it. Canada is reasonable. Canada might cost you $1,600, $1,700 for filing, all in, my fee, government fee, foreign associate fee. Generally, filing will cost you in the neighborhood. India will cost you about $1,200. It's the cheapest. Generally, in the neighborhood of, I'd say, $1,200 to $2,500 to file in foreign countries, all in with the fees for filing. European Union will get you all the European countries. It costs you about $4,000. And they fall within that range. With most other countries, UK only is about $1,800. And then it's examination. It depends what happens in their office actions and their search reports and their whatever, how much you go back and forth. But I guess I would tell the company budget minimum $5,000 per country, more for Europe and Japan. Maximum 10, 15, maybe even $20,000 per country. Probably pushing it. If your application is getting rejected everywhere, you can spend a ton everywhere. But if you know your application is good, then you're going to prosecute it all the way through in the other countries. So then hopefully it becomes a more streamlined process, and you know, both it becomes a little more cost effective. But say at least budget $10,000 per country. Yes.
I have a question about like the IC codes for trademarking.
Yeah.
So if I'm looking into it, and basically some of our competitors or the players in the field are all using one IC code.
Okay, so hold that question because I'll go through. I didn't talk about classes and trademarks. So she's talking about ICs or international classes. Okay. And when I look up his, we'll talk about the goods and services and international classes at the same time.
Perfect.
Okay. Yes.
In case of, let's say you're looking for investment money, right?
Yes.
And let's say some investors might not want to sign an NDA.
That is very common. Investors usually don't want to sign NDAs, which is why you need to file the patent first.
What if you don't have the money to file the patent first? Because you're trying to make it to the bidding.
Got relatives?
With provisional.
It's something, yeah, because then you can at least disclose, but, yeah, I mean.
Like just, what are the boundaries between disclosing something? Having somebody sign an NDA doesn't mean.
I would not disclose without an NDA. Without a non-disclosure agreement, I would not disclose something which is patentable, period. That would be my recommendation.
And if you do the provisional first, then can you do it without the NDA?
You can. It's not the best idea, but you could. You're at least then, you know, you got something there, and it shows what date you were possession and ownership, and a patent is much better than any NDA. You know, trying to sue for an NDA compared to trying to sue for patent infringement, it's again, it's like trying to prove, once you have something, the same thing that I was saying with trademarks, once you have something registered and recognized by the government, it's there, you can look at it, you can see what's protected, anyone else is infringing. Whereas your contractual relationship with another person, you got to prove it. You got to prove your case if it's not already recognized by the government. Whereas once it's registered, the burden is on the other person. The burden is, hey, this is there. They have to prove it or not.
Then on the same amount of time from when you can disclose it to like investors, how much time does it take from, let's say I come to your office today, what's like a guesstimate of?
To do a provisional?
No, like when are we able to file like the patent?
Again, about two months usually to do a non-provisional. It's usually the same. If you need more, I'm sure we can work it out. You know, but you said you don't have the money, so I'm not so sure.
No, I'm just
I know. Okay. Yes.
Say you invented something. It's a website, for example. It goes up live in July, and then you apply for a patent like 3 months later. Who, you know, if somebody copies you after you make it live, and then you file the patent, who's going to win out in that case, do you think?
Well, right now it's still first to inventor system. So if he's the first to invent, he's going to win. If you're the first to invent, you'll win. And meaning by win, if you have the patent, you can now sue him for damages or injunction against him doing it.
Mm-hmm.
Whereas if he's the first, he's able to do it. You might still have your patent, you might not, but he won't be able to sue you for damages because he has no patent. Well, there might be other ways, but generally speaking. Yes?
If I know someone else is filing a patent and I would release the design to the public, general public openly, prior to that patent being approved, would the other person be able to stop me from sending out this kind of information to the public for free?
Well, what you can do, I think the question is really, if there's a pending patent and you infringe, what rights does the owner of the pending patent have? And in that case, if it's published, he can send a cease and desist letter. He can say, I'm putting you on notice. I expect this patent to issue. When it does issue, I will sue you for willful infringement damages, which are absurdly high, for willful infringing my patent back to the date of publication. So you can request early publication. You can have it published within a few months after filing. It typically is published 18 months after filing, and you basically sue for retroactive damages, and you can put a person on notice to make it willful infringement, and your damages are much higher. All right, let me get to some trademarks. That's me. So uspto.gov. Oh, that's interesting. They just changed their website. It's not a good time for them to change it on me when I need to find stuff. Our former home. I'm going to use that for now. That's fair. Search.
That was yesterday. They must have just changed it.
I think they just changed it yesterday.
I just got an email that they just changed it.
All right. Okay. What was over there? What was in the back of the iPhone? What was the mark? What was the one you said?
I was just asking how Donald Trump said,
you're fired? You're fired. All right, so I'm going to do a quick and dirty search here. As my apprentice, you're never... All right, that's somebody else's. Okay. It turns out there's a hell of a lot of monks for you're fired. Most of them are dead, meaning the people didn't pay the renewal fees or they weren't allowed to begin with. So let's look at some of the live marks. Well, this one is kind of different, but here, look at this. This one's actually registered, see it's got a registration number. And let's look at this one. So this one, you're fired for beverage glassware. So how do you read this? This is at the Trademark Office database. So you're fired is a word mark, there's the name of the trademark, International Class 21. International classes, there's a question on it. Trademarks are in different classes depending on the goods. So I actually have over here, trademarks, trademark international classes. So these are the classes. So like class 1 is chemicals, I mean IC, for example. Class 25 is clothing. So I do a lot in that category. So 21, household and kitchen utensils and containers. So that's what this one is. It's international class 21. So government charges you a different fee for every international class. And sometimes they make sense, sometimes not so much. If you're filing for beverages and glassware, it's international class 21. If you're then doing a chemical cleaner called You're Fired, that's a good name to me, it's class 1. So it would be 2 separate classes. And they're saying they're actually using it since 2004. So that's okay, because You're Fired is a phrase with secondary meaning. Now I'm creating a new meaning. You're fired now means this type of glassware as opposed to firing somebody. And here's another one. So this is class 41, which is a service mark once they get to high numbers in some kind of service, providing studio facilities to paint your own pottery. That's cute. You're fired for firing pottery. So in terms of Trump, it's a very good question. Obama, you're fired. You were fired to Donald. Is that it? It's a band. Oh, this is interesting. Owner Donald Trump. Here it is. It's filed 2004, abandoned 2005. He never actually used it, but he was going to have You're Fired for class 16 paper goods, 18 home furnishing, pillows, housewares, linens, toys, and sporting goods.
I think he sued somebody over this. And that's, I think it was, he had an active one somewhere. That's why I asked.
I'm not going to defend him.
Yeah.
Just a question about the U.S. classifications then. So we understand about the IC codes and
Yes.
the different categories.
Yes.
But it seems that I was looking into it, the U.S. codes are very, very antiquated. Who assigns those? Do you pick them out, or do they look at it and assign a few of those codes?
I mean, the answer to both of those is, I guess, could be yes. This is interesting. Okay, I'll answer that question one sec. I'm just looking. The whole trademark files are online. You can look at anyone's trademark. He actually got refused in class 28, which I have to go back and see what that was. And then I can look up these marks and see why he was refused registration. This is a likelihood of confusion because he was too similar to other marks. Prior pending applications. These are all ahead of him, which might be problematic. And then here's identification of goods. So this actually goes right to your question perfectly. So the Trademark Office said, and they're the most pedantic in the world, when I file trademarks coming from other countries, they might file for paper goods in Europe. It's, I think the office in Switzerland, WIPO. And it'll be fine. It comes here, the same mark that they've been using for 10 years in Europe, gets rejected. So that's not good enough. Paper goods, namely what? You got to be specific. So generally what I do is I use their automated system where I pick out from the trademark list a list of goods and services which are already, it says what is already accepted, what classes you can use, because I don't get these rejections. It's much cheaper for the client later. Okay. Because I used to file them on paper, my previous job. Old guy did everything on paper. We had to write all these out, and they would say, that doesn't belong in International Class 16, that belongs in 18. And your description isn't good. We'd sit there amending it and going back and forth with the examiner. The online system has largely done away with it, with people who use it, because I just select the goods, I know the classes it goes in, and I can tell you at the time of filing what they're going to accept and what not.
So can you, they also have a thing where you can request something to be added to the ID manual.
Don't bother.
Don't bother, it's not going to work?
I mean, that is, it'll work eventually.
Okay.
You know, maybe. They're going to have to get enough requests, and there's going to probably one person in charge of adding the stuff to the database, or worse, a committee, and it may or may not ever get added. But for your purposes, it'll get added in 1 year, 2 years. You're gonna have to file well before then. If there's, I can't recall a case where I've ever not been able to fit in with the things that you can select,
Okay.
because some of them are also open-ended. So it might be paper goods, and you're allowed to add in the description. But if you really have that problem, then you can enter it freeform. You can do that,
You can
and it
enter
can
it
still be accepted.
It
Yeah.
can be accepted?
Yeah, but this is getting to more specific. All right,
Okay.
and then there was one other. It was yours, I think.
Yeah. Do you want the mark name?
Oh yeah, let's look up your mark, and let's see what went on there.
Okay, it was storage by mail. Can't remember if I used the .com or not on that.
Storage.
I think I fell into this one word.
By mail, look at it.
Mail.
Oh, mail. Storage by mail. So storage by mail, LLC. Whatever here, I'll go here. So it's filed 2009, abandoned 2010 for In-Touch Class 39 air transport storage goods. So we can go look up what happened there. So you had an office action.
Did you present at one of the meetups?
Yeah.
I remember that. I tell people about that all the time.
Oh. So no confusingly similar marks, but it was merely descriptive.
Yeah.
Because, as they write here, it describes an ingredient, quality, characteristic, function, feature, purpose, or use of specified goods or services. Because you're describing storing by mail. So you're storing stuff based on the mail. I might argue this one. I think there's room to argue that it's not really descriptive. I don't really know. You know, is it really clear what services you're doing? But what you could have done is right here. This is what many people miss. Sometimes it's not in the office action, but if the examiner's writing properly, they put it on. Although it's refused, you may submit evidence in support of registration. If you choose to respond, you may also, oops, I'm sorry, that's not what I thought it was. You can get on the supplemental register. That's not the paragraph I thought. You can respond to it with arguments that it's not descriptive. It's not merely descriptive of your goods. I don't really know what you're doing. And you can also cancel some of your goods. Like if I file applications, there's different opinions on this. I generally file them with a short list of goods and services. When we did them on paper, we used to do real long because in case one wasn't accepted, we got others. But a short list is okay because it's also likely and confusing. Anything that's confusingly similar. So I might just do a short list and leave the ones that are going to get through, which aren't so descriptive-like, and say, well, it's not descriptive for this service, and then argue it. But the other thing is, once you're actually using this mark, you can get it on the supplemental register. And on the supplemental register, you don't get the same gem, you just use the R with the circle, and once you're using it for 5 years, you get primary.
What are the drawings for trademark? A logo or something?
Well, a logo, you might have drawings for the logo. You might have the logo if it's a logo mark, because you can protect the logo instead of just the words.
You have to have it?
No, yeah, and they're two separate things. I could break the name storage by mail. I could file a separate application for his logo. And then you need to submit a specimen of use. You need to show you're actually using it to get the name. So you submit a sample of whatever it is, storage by mail on his storefront or whatever the case might be.
Could it be a website? Like
It depends. It depends what it is. For a service mark, yes. For a word, for a regular trademark, it's got to be on the product you're actually selling. So if your product is website services, yeah. If your product is canaries, it's got to be a picture of a canary box that says a name on it. You know, whatever it is. All right. Do we have 11 o'clock? So yes.
One quick question: if you get a domain name, do you always get a trademark?
No, totally different systems. Domain name and trademark are
I'm just saying to protect your domain name is one thing.
You should do it, because then when you get that fraudulent letter from the Chinese ISP, that thing in China today, that says, someone tried to register your name .cn and .hk and pay us $500 to register it first, then you'd be like, that's not really a problem, I have the trademark. You know, that type of thing. Okay, it's 11 o'clock, so I'm going to stick around a little more to answer questions. Yeah, you can cut off the video. And I guess come up to me if you have more questions. And that is all. Thank you for attending, and this was a very good audience.